Hello guys, I'm Oğuzhan Tolga Yeşilli. I hope you're all doing well, and in this presentation I will talk about e-justice, the meaning of e-justice, advantages and some disadvantages of e-justice, some important concepts about e-justice and some other stuff. I hope it's going to be an enjoyable and informative presentation. So let's start with the meaning of e-justice. So, e-justice can be defined as the use of technology, information, and communication to improve access of citizens to justice and effective judicial action, which consists of dispute settlement or the imposition of criminal sanctions. So, if we sum up of this meaning, it is basically like using technology in justice area. And now, how did e-justice evolve? Investment in information and communication technologies can be considered as one of the key elements to improve the administration of justice and enhance the role of law in society. The growing attention to ICT helped to improve the efficiency and effectiveness of the administration justice as well as to promote the confidence in justice system has given rise to a new term called e-justice. So what we mean here is that if you invest in something more than you usually did, it's going to develop more. And when it is more developed, the more people will trust it and they start to use it. And for that reason, e-justice has become a popular word in this world nowadays. And here we have some objectives of e-justice. As you can see, one of the objectives of e-justice is access for individuals and businesses to justice, more effective judicial cooperation, mediation, facilitating the use of video conferencing, continuing the interconnection of criminal records, enforceability of judgments, and translation assistance. Those are the most important objectives of e-justice. And now I will talk about advantages of e-justice. Reduction of the cost of justice, easier access to information. And what we mean here, why we are saying easier access, is that you don't need to go anywhere for your justice jobs. For example, you can do it with your phone by using the e-justice systems. Enhanced data security, minimization of chances of cooperation, speeding up proceedings. Speeding up proceedings is more like easier access to information because, again, you don't need to go anywhere. You can just do it with one click on your phone. Having capacity to handle more cases with fewer staff. And if we have some advantages, we can also have some disadvantages of e-justice. For example, it requires time to put all case files into a digitalized form papers. So, as you know, e-justice is a very brand new concept, and before the e-justice, all of the documents that we are using in our justice systems are written on the papers. And if we want them to become digitalized form, we need some time to put all these files into a digitalized form. E-justice system can suffer from hardware, software, and equipment failures. And the last one is the court need to have skilled staff to keep high-level components of e-justice running. So we are dealing with technology, and if we are dealing with technology, we need someone to know about technology well, because technology is like a hard stuff. Not everyone can do that. Now I'm gonna give some information about important concepts about e-justice. And our first concept is e-courts. Virtual courts is a concept aimed at eliminating the presence of litigant or lawyer in the court and for education of cases on a virtual platform. The concept has been evolved in order to efficiently utilize court resources to provide litigants with an effective avenue to settle petty disputes. Conveniences of e-courts. Virtual court can be administered by a judge over a virtual electronic platform whose jurisdiction may extend to the entire state. Neither litigant nor judge will have to physically visit a court for effective adjudication and resolution. Communication will only be in electronic form, and sentencing and further payment of fine or compensation will also be accomplished online. So when you have when you have a job in court, it says that you don't need to go to court because the lawyer or the other people who are responsible with the courts are not going there in e-court systems, because all the courts will be online and all the settlements, payments, and sentencings, they also will be online. And another concept is e-law. E-law is the area of law that deals with the Internet's relationship to technological and electronic elements, including computers, software, hardware, and information systems. E-law encompasses aspects of intellectual property, contract, jurisdiction, data protection laws, privacy, and freedom of expression. It directs the digital circulation of software, information, online security, and e-commerce. So, importance of e-law. It dictates all actions and reactions in cyberspace. All online transactions are ensured to be safe and protected. All online activities are under watch by the cyber law officials. Security for all data and property for individuals, organizations, and government. Helps curb illegal cyber activities with due diligence. All actions and reactions implemented on any cyberspace has some legal angle associated with it. Keeps track of all electronic records. Helps to establish electronic governance. So we talk about the importance of e-law, and now we need to talk about why do we need e-law. The number of the people that use the internet is over 4 billion in this world. It initially started off as an information tool, but as you know, today it is around everywhere. It helps with communication and commerce. The usage of internet has become common, hence the increase in cybercrimes is inevitable. Given the swift increase in the use of internet, implementation and the usage of skilled internet rules, it helps establish a safe and secure environment for the users. So it is basic is we need it because we need protection, right? We need someone to protect us. If we do not have laws about the internet, the people can do whatever they want out there, and it might hurt some people. So we need some restrictions for the protect other people, and for that we need e-law. Artificial intelligence in justice. AI-powered tools and machine learning can provide deep insights into people. These technologies excel at detecting patterns humans sometimes miss. AI uses algorithms to analyze large sets of data to find solutions and make predictions. How artificial intelligence can be used in justice system. The use of AI in justice system depends on first identifying various legal processes where the application of this technology can reduce dependency and increase efficiency. The mission first needs to perceive a particular process and get information about the process under examination. Over time, the machine can learn from experience, and as we provide more data, the program learns and makes predictions about documents, thereby making the underlying system more intelligent every time. So as we make something with artificial intelligence, it will learn from us, and for the continuous processes, it will make it better. This requires the development of computer programs and software, which are highly complex, requiring advanced technologies. So, Estonia was the first country to strive for the operation of AI judges in courts, because Estonia was already a highly digitalized country in public sector. A national ID card system, e-voting, digital tax filing, digital signatures, online healthcare records, as well as an e-residency program, which allows commencement of business within European Union from a remote place, are all part of Estonia's national e-governance project. So it's the end of my presentation. I hope you all doing a fine day, and thanks for listening my presentation.
Hello everyone, I am Olcan Kılınç and now I will explain legal issues, but firstly I want to talk about the Internet law. What is Internet law? Internet law refers to how legal principles and legislation govern the use of the Internet in all its forms. Another term for Internet law is cyber law. Unlike other areas of the law, Internet law cannot be identified as one solid, stable and specific field of practice. Rather, it incorporations and applies principles from several traditional fields such as privacy law or contract law that predate on Internet. Internet law can include the following. Firstly, laws related to the creation of websites. Secondly, laws governing Internet service providers. Thirdly, laws related to how trademarks are used online. Fourth, laws regarding how to resolve conflicts over domain names. And lastly, laws related to how to link web pages. What are top Internet law issues? Firstly, domain name acquisition. Domain name acquisition considerations. Companies and brand owners secure domain names relevant to their brands for online business. However, business owners should consider intellectual property factors at time of domain acquisition. This is most important for new business owners starting a new business and picking a company name and domain. Domain names can potentially infringe upon another's trademarks or brand name. Domain despite dispute avoidance to avoid malicious practice such as cyber squatting, typo squatting, username squatting, or online impersonation. The Internet Corporation for Assigned Names and Numbers has implemented a number of practices to deter misuse. For example, ICANN currently enforces a 60-day waiting period on domain transfers. Similarly, ICANN allows for the locking of domains to make domain theft more difficult. Sites that can legally obtain domain addresses, for instance, Bluehost, HostGator, IronHost, HostGator.com, GoDaddy.com, DreamHost, HostPapa, and A2 Hosting. Secondly, policies regarding online marketing. When online business first opened, the government was not yet equipped to resolve legal issues. Nowadays, most businesses represent themselves online and law has begun to catch up. The nation's official consumer watchdog, the Federal Trade Commission, investigates and fines parties for using unfair and deceptive marketing tactics. At the same time, Google can also penalize websites. The agency also deals with unfair competition. Unfair and deceptive marketing can vary based on context, but it generally applies to the following. Firstly, lying, making untrue statements about items or services. Secondly, describing unusual results as typical. Falsely labeling an item all natural. making general health-related assertions that are not backed by medical or scientific proof, making funny news websites or purchasing website reviews, and another attempting to stop negative reviews via contractual gag clauses which restrain freedom of speech, fooling web searches into registering for funny, repeat billing situations via negative option tactics, playing with words to trick them into agreeing, and another discussing ads to seem like regular web page material, and last, releasing customers' information without their consent. And now, penalties given by Google to famous sites. Over the past 2 decades, there have been a number of high-profile Google search penalties. These penalties range from innocent mistakes to blatant disregard for Google's guidelines. Some of these penalties are algorithmic, some of them were manual. For instance, firstly, Forbes. Forbes and a bunch of other news sites were punished by Google in 2011 for selling links from their websites. Most of the high-profile penalties are due to buying links. This one was due to selling links. Secondly, Mozilla. Mozilla was penalized in April of 2013 for UGC spam or user-generated content spam. Thirdly, Interflora. On February of 2013, Interflora, a high-profile flower delivery aggregate, was penalized by Google for violation their webmaster guidelines, specifically the backlinks portion of it. And last, Overstock.com. In February of 2011, Overstock.com got hit by Google for offering discounts in exchange for linking to their websites. Thirdly, intellectual property in Internet law. Copyright protects authors' rights to their own material so that other people cannot manipulate, steal, or earn profit from it. Naturally, copyright applies to online content just as it does to more tangible work. It is helpful for organizations and individuals to place copyright and trademark signs on their websites and other materials to express their ownership and warn people not to steal or misuse their work. Likewise, businesses should formally register their domain names to prevent cyber squatting. This has become harder, tough, since many endings besides .com are now possible. Basic principle about this topic: you cannot steal a copyright, trademarks, or patent, and you certainly cannot profit from doing so. Secondly, you should check for a Creative Commons or fair use agreement before using another party's photograph or other visual. And another principle: you are unlikely to be able to copyright website codes. And another: if you wish to hear ghostwriter, receive formal acceptance from them that you will use their work exclusively for your means when they have finished its writing. Otherwise, they may still own the rights to their work. And plagiarism must still be avoided even when article spinning. Although using a competitor's name and AdWord marketing ploy is fine, it's best consult with a lawyer on the wording of the posts. And last, online piracy is not permitted. Fourth, Internet laws regarding online defamation. Both state and federal defamation laws govern libel and slander online. To win a libel case, you must prove that a claim was false, harmful, and negligent. Opinion is not necessarily slander or libel under US law, but if the opinion is mixed with untruths or manipulations of the truth, it can be considered defamation. In some cases, the identity of an anonymous author can be uncovered for a libel lawsuit. Often, Online libel cases are resolved without a full court case, and fraud can be used as a defense in slander and libel cases with exceptions. Sometimes libel can be removed or redacted from online forums. And last, for famous people, the rules are different. People figures need to meet a higher standard of evidence when charging someone with slander or libel. 5. Data use notices. A data use notice should be included on any site that collects personal data. The notice should define the reasons and uses for the data collected, including any data gleaned through cookies or hidden programs. In the case that information is admittedly used for promotional or business purposes, or any other reason that is a non-service to the consumer, the user must agree to this, usually via opt-in selections. 6. Laws governing online privacy. Firstly, the Children's Online Privacy Protection Act. Secondly, the Computer Fraud and Abuse Act. And thirdly, the Health Insurance Portability and Accountability Act. And 7. Photo sharing law. It is common nowadays to share photos of yourself and your friends via social media. However, sometimes people steal photos, post them, and then request funds for their removal. This is an example of how behavior on social media can have major real-world consequences. Such situations can be difficult to resolve, especially given that the perpetrator may be in different country. And last, computer hackers and crime. If someone enters your computer system virtually or physically and uses it to do illegal things, you may or may not be liable. It depends on the specifics of the case. And that's all. Thank you for listening.
Hi, I'm going to talk about security in e-business, e-commerce. What is e-commerce security? E-commerce security refers to the policies that provide secure online transactions. It consists of protocols that protect those who sell and buy products and services online. You need to gain your customers' trust by putting in place e-commerce security basics. Such basics include privacy, integrity, authentication, and non-repudiation. Privacy. Privacy includes preventing any activity that will lead to the sharing of customers' data with unauthorized third parties. Apart from the online seller that a customer has chosen, no one else should access their personal information and account details. A breach of confidentiality occurs when sellers let others have access to such information. An online business should put in place at least a necessary minimum of antivirus, firewall, encryption, and other data protection. It will go along in protecting credit card and bank details of clients. Integrity. Integrity is another crucial concept of e-commerce security. It means ensuring that any information that customers have shared online remains unaltered. The principle states that the online businesses is utilizing the customer's information as given without changing anything. Altering any part of the data causes the buyer to lose confidence in the security and integrity of the online enterprise. Authentication. The principle of authentication in e-commerce security requires that both the seller and the buyer should be real. They should be who they say they are. The business should prove that it is real, deals with genuine items or services, and delivers what it promises. The clients should also give their proof of identity to make the seller feel secure about the online transactions. It is possible to ensure authentication and identification. If you are unable to do so, hiring an expert will help a lot. Among the standard solutions include client logins information, and credit card pins. Run repudiation. Repudiation means denial. Therefore, non-repudiation is a legal principle that instructs players not to deny their actions in transactions. The business and the buyer should follow through on the transaction path that they initiated. E-commerce can feel less safe since it occurs in cyberspace with no live video. Non-repudiation gives e-commerce security another layer. It confirms that the communication that occurred between the two players indeed reached the recipients. Therefore, a party in that particular transaction cannot deny a signature, email, or a purchase. Now I'm going to talk about e-commerce security threats. There are a number of threats to your online store which you must guard against. Hacking, exploitation of personal data, monetary theft, phishing assaults, unprotected supply of services, and credit card fraud are all instances of security threats. Let's look at a handful of the most frequent ones that affect online enterprises. Firstly, financial frauds. Financial frauds have afflicted online businesses since their inception. Hackers make unauthorized transactions and wipe out the trail, costing businesses significant amounts of losses. Spam, where emails are known as a strong medium for higher sales. It also remains one of the highly used mediums for spamming. Nonetheless, comments on your blog or contact forms are also open invitation for online spammers, where they leave infected links in order to harm you. Phishing. Phishing it is one of the common security threats of e-commerce, where hackers masquerade as legitimate businesses and send emails to your clients to trick them into revealing their sensitive information by simply presenting them with a fake copy of your legitimate website or anything that allows the customer to believe the request is coming from the business. For DDoS attacks, distributed denial of service attacks, and denial of service attacks aim to disrupt your website and affect your overall sales. These attacks flood your services with numerous requests until they succumb to them and your website crashes. And there's an image like shows how DDoS attacks works. You can see the numerous requests of that attackers sent to websites. And 5. Injections into SQL. SQL injections are cyber attacks that target your query submission forms in order to gain access to your database. They infect your database with malicious code, capture data, and then remove it later. And we have an image that shows how injections into SQL works. Now I'm going to talk about e-commerce security tools, which e-businesses use to protect them to these attacks. Firstly, firewalls. They could be both software and hardware, and public key infrastructures, encryption software, digital certificates, digital signatures, biometrics, password, locks, and bars. Firewalls. Firewalls are frequently used to prevent unauthorized internet users from accessing private networks connected to the internet, especially intranets. All messages entering or leaving the internet pass through the firewall, which examines each message and blocks those that do not meet the specified security criteria. Public key infrastructure. Public key infrastructure (PKI) supports the distribution and identification of public encryption keys, enabling users and computers to both securely exchange data over networks such as the internet and verify the identity of the other party. The purpose of PKA is to facilitate the secure electronic transfer of information for a range of networks activities such as e-commerce, internet banking, and confidential email. And we have encryption software. Encryption is a generic term that refers to the act of encoding data in this context so that those data can be securely transmitted via the internet. Encryption software is a software that can encrypt and decrypt data, often in the form of files on a hard drive or packets sent over networks. Software encryption is a fundamental part of modern computer communications and file protection. The purpose of encryption is to prevent third parties from recovering any of the original data or even any information about the data from the encrypted data. Digital certificates. Digital certificates are means by which consumers and businesses can utilize the security applications of public key infrastructure. PK comprises the technology to enable secure e-commerce and internet-based communication. Digital signatures. Digital signatures are the public key primitive of message authentication. In the physical world, it is common to use handwritten signatures on handwritten or typed messages. They are used to bind signature to the message, and we have image that shows that the difference between electronic signature and digital signature. Biometrics. Biometrics generally refers to the study of measurable biological characteristics. In computer security, biometrics refer to the authentication techniques that rely on measurable physical characteristics that can be automatically checked. There are several types of biometric identification schemes. Face: the analysis of facial characteristics. Fingerprint: the analysis of individuals' unique fingerprints. Hand geometry: the analysis of the shape of the hand and the length of the fingers. Retina: the analysis of the capillary vessels located at the back of the eye. Iris: the analysis of the colored rings that surrounds the eye's pupil. Signature: the analysis of the way a person signs his name. And that's all. Thank you for listening. Have a good day.
Hi everyone, I am Nurevşan Kurak. I am going to talk about privacy on internet. These are my topics about my subject. Let's start. What is data privacy? Data privacy generally means the ability of a person to determine for themselves when, how, and to what extent personal information about them is shared with or communicated to others. This personal information can be one's name, location, contact information, or online or real-world behavior. Just as someone may wish to exclude people from a private conversation, many online users want to control or prevent certain types of personal data collection. Why is data privacy important? Data privacy is important because in order for individuals to be willing to engage online, they have to trust that their personal data will be handled with care. Organizations use data protections practice to demonstrate to their customers and users that they can be trusted with their personal data. For individuals, any of these outcomes can be harmful. For a business, these outcomes can be irreparably harm their reputation as well as resulting in fines, sanctions, and other legal consequences. Personal data can be misused in a number of ways if it is not kept private or if people don't have the ability to control how their information is used. Firstly, criminals can use personal data to defraud or harass users. Then, entities may sell personal data to advertisers or other outside parties without user consent, which can result in users receiving unwanted marketing or advertising. Next, when a person's activities are tracked and monitored, this may restrict their ability to express themselves freely, especially under repressive governments. What are the laws that govern data privacy? In many jurisdictions, privacy is considered a fundamental human right, and data protection laws exist to guard that right. As technological advances have improved data collection and surveillance capabilities, governments around the world have started passing laws regulating what kind of data can be collected about users, how that data can be used, and how data should be stored and protected. Some of the most important regulatory privacy frameworks to know include, first of all, General Data Protection Regulation regulates how the personal data of European Union data subjects, meaning individuals, can be collected, stored, and processed, and gives data subjects rights to control their personal data. Another data protection laws in many countries, such as Canada, Japan, Australia, Singapore, and others, have comprehensive data protection laws in some form. Like Turkey's general law for the protection of personal data in Turkish Kişisel Verileri Koruma Kanunu, KVKK, is quite similar to the GDPR. There are also industry-specific privacy guidelines in some countries. For instance, in the United States, the Health Insurance Portability and Accountability Act governs how personal healthcare data should be handled. In our country, our personal data is protected by a law. The law in the protection of personal data, KVKK, is the law that regulates the obligations of natural and legal persons who process personal data and the rules to comply with regarding the discipline of the processing of personal data based on the privacy of private life. The purpose of KVKK is to process and protect personal data within the framework of certain standards and to prevent unauthorized use by unauthorized persons in an unregulated and unlimited manner. The law covers all institutions, business and company owners that process personal data, including official institutions. If the information of real person, customers, employees, visitors is recorded and processed, it is within the scope of KVKK in Turkey, of course. All institutions and organizations within the scope of the law are obligated to register in the Data Controllers Registry Information System, whose short name is VERBIS, within the dates determined by the Personal Data Protection Authority. According to the law, users should be informed whenever their personal data is processed. It's called lighting obligation. In this regard, it is a clear, understandable, and plain language that is free from terminology, proving that the data controllers fulfill their obligation to inform. As you can see, it's a form. According to the article of the Law on Data Security, the data controller, to prevent the unlawful processing of personal data, to prevent unlawful access to personal data, to ensure the protection of personal data responsible for. While the law imposes serious administrative fines on institutions and business owners, in some cases there are also prison sentences. Penalty range from the 9,000 to 1,800,000 liras, as you can see. Then also prison sentences range from 1 year to 4 years. The general principles listed in the law in the processing of personal data are as follows. Firstly, compliance with the law and honesty rules. Secondly, being accurate and up to date when necessary. Then processing for specific, explicit, and legitimate purpose. Fourthly, being connected, limited, and restrained with the purpose for which they are processed. And finally, to be kept for the period required by the relevant legislation or for the purpose for which they are processed. What are some of the most important technologies for data privacy? As you all know, these are encryption, access control, two-factor authentication. First of all, encryption. Encryption is a way to conceal information by scrambling it is so that it appears to be random data. Secondly, access control. Access control ensures that only authorized parties access systems and data. Then finally, two-factor authentication is one of the most important technologies for regular users, as it makes it far harder for attackers to gain unauthorized access to personal accounts. Since data privacy directly affects our private life, let's take these precautions and not risk our security. Thanks for listening.
Hello, my name is Yunus Emre Berhan. My department is Management Information System. My topic is e-justice in Turkey. When you think of e-justice in Turkey, the first thing that comes to mind is UYAP. What's UYAP? National Judiciary Informatics System. What's UYAP? UYAP is an e-justice system as a part of the e-government which has been developed in order to ensure fast, reliable, soundly operated and accurate judicial system. As a central network project, it includes all of the courts, public prosecutors, services, prisons, other judicial institutions and other government departments in Turkey. What do we need to connect UYAP? First, e-signature. 2. Mobile signature. 3. E-government. This photo. Objectives of UYAP. First, to serve employees of Ministry of Justice, lawyers and citizens. 2. Integration of judicial units with each other and with other justice agencies. 3. Prevent citizens from injustice treatment. 4. Rapid, efficient, reliable, and integrated system. 5. Fast and efficient data exchange. 6. Cheaper judicial services. 7. Data standardization. 8. Electronic means instead of paper files. This photo, see. 9. Data bank of information. 10. Flexibility of working hours. 11. Audio and video record system. Speed and efficiency of operations. We have created fast, secure, and efficient information system by transferring key business processes of the judicial system into central electronic means. Instructions to other courts in order to collect evidence can be instantly sent and received online. Access to information and make transaction online instant and secure. Date bank of web. First, legislation. 2. Directives. 3. Sentences. 4. Case law. 5. Judicial essays. 6. Template text. 7. Circular acts. Portals of web. These have 6 portals. First, Citizen Portal. 2. Lawyer Portal. 3. Corporation Portal. 4. Expert Portal. 5. Mediator Portal. 6. Conciliator Portal. First, the Citizen Portal. It's a service offered by the Ministry of Justice for citizens to follow their own judicial and administrative courts and enforcement office electronically. SMS messages can be sent to people who need to be warned when to attend court. This photo, Citizen Portal. Lawyer Portal. Lawyers can follow litigation and enforcement proceeding, and they can examine the open and closed files in the system within their authority by connecting Lawyer Portal of UAP. Lawyers can also send documents to the case files in the system, access information about the states, inquire about hearing days, and pay fees and expense online. Corporation Portal. UAP Corporation Portal is a service offered by the Ministry of Justice in order to enable private companies or public institutions to follow the case files they have electronically. Expert Portal. It's a service offered by the Ministry of Justice in order for people who work as experts in the judiciary throughout Turkey to follow up on their files electronically without going to the courthouse. Mediator Portal, finally, is a system in which the files of the mediation solution method, which can be applied as an alternative solution method in disputes the court phase and after the court, are deposited throughout offices. The mediation process is followed and terminated and is only available to registered mediators. Project plan with milestones. Revision in 2000. Composing of the project schedule in 2001. Analyzing of the process 2002. Design of the system and production of programs and screens in 2003. And then testing system and new products at the end of the 2003. Implementing of the project in pilot units at the beginning of the 2004. Then project start to roll out in whole Turkey at the beginning of the 2005. Conjectural projects Finish time end of 2007. E-Judgment and UYAP phases. UYAP 1 Ministry of Justice, UYAP 2A and 2B Analysis and Hardware, Record of Convictions and Statistics, Record of the Convictions and Statistics, UYAP 2C Civil Litigation, Administrative Law, Lawyers, Citizens, UYAP Supreme Court, Supreme Court. This page. And this is the video watching.
Merhabalar, ben Ankara Yıldırım Beyazıt Üniversitesi E-Devlet ve Kamuda Dönüşüm Tezli Yüksek Lisans Öğrencisi Serhat Polat. Bu sunumumuzda Dijital Türkiye Endeksi bağlamında adalet tematik alanının analizini yapmaya çalışacağım. İnsanların avcı toplayıcı dönemin gücü yeten yetene şartlarından sıyrılarak birbirlerine karşı can, mal gibi temel güvenliklerini teminat altına almak amacıyla bir otoritenin kaideleri altında özgürlüklerinden tabiyle kavramsallaştırılmış ve neticede devlet kavramının temel varoluş felsefesi olarak kabul edilmiştir. Gerek bireylerin kendi aralarındaki olası kötülüğü bertaraf etmek, gerekse zayıf olan bireyi güçlü olan devletin şerrinden koruma ihtiyacı, adalet kavramını gündeme getirmiştir. Neticede toplumun ve idarenin davranışları yönetmesiyle de hukuk kavramı ortaya çıkmıştır. Devlet, adalet gibi kavramlar, bir düzenin sağlanması için birbirinden bağımsız düşünülemeyecek, olmazsa olmaz soyut kavramlardır. Her ne kadar bugüne kadar devlet deyince kamu binalarını, adalet deyince adliye saraylarını kafamızda canlandırsak da günümüzde kısmen gelecek yarında hem devletin hem adaletin dijital ortamda uygulamalı iz düşümünü iyiden iyiye tecrübe edeceğiz. İçinde bulunduğumuz çağda bilginin önemine binaen bilgi teknolojilerine talep artmış ve bilgi teknolojileri hayatımızın her alanında olduğu gibi devletlerin de iş süreçlerinin hızlı, etkin ve tasarruflu kullanılması için dijital dönüşümü bir zorunluluk haline getirmiştir. İnceleme alanımızda devletin dijital dönüşümü kapsamında adalet alanının ne kadar dijital olduğunu, Dijital Türkiye Endeksi projesi bağlamında tespit ettiğimiz bileşenler temelinde incelemeye çalışacağız. Çalışmamızda öncelikle adalet tematik alanının bileşenleri tespit edilmeye çalışılmış ve bu bileşenler şematik olarak slaytta görüldüğü şekilde gösterilmiştir. Anayasa Mahkemesi Başkanlığı ve Uyuşmazlık Mahkemesi Başkanlığı hariç olmak üzere KAYSİS verileri referansı ile Adalet Bakanlığı, Danıştay Başkanlığı, Yargıtay Başkanlığı hizmet envanterleri çıkarılmış, hizmetlerin her birinin işlem sayıları da dahil olmak üzere dijital olup olmadığı tespit edilmeye çalışılmıştır. Neticede adalet tematik alanına yönelik olarak 306 adet hizmet tespit edilmiş olup 171 adet hizmetin dijital olmadığı, 135 adet hizmetin ise dijital olduğu anlaşılmıştır. Bu da toplam tespit edilen talep ve hizmetin %55,8'inin fiziki, %44,2'sinin ise dijital şartlarda ifade edildiği anlamına gelmektedir. Hazırladığımız listede KAYSİS verilerine göre dijital olmayan ama en çok işlem sayısına sahip olduğu tespit edilen 10 hizmet şu şekilde gösterilmiştir. Tablodan da anlaşılacağı üzere listemizin en çok işlem sayısına sahip hizmeti olan adli sicil silme ve düzeltme taleplerinin alınması süreci fiziki şartlarda gerçekleşmektedir. Gerek vatandaş açısından, gerekse ilgili kamu kurumu olan Adalet Bakanlığı'na bağlı Adli Sicil ve İstatistik Genel Müdürlüğü açısından öncelikle dijitalleşmesi gereken hizmetlerin başında gelmektedir. Keza vatandaş açısından düşünüldüğünde adli sicilinde olmaması gereken yanlış ya da silinmesi gereken bir bilginin kişilik hakları açısından en ivedi vasıtalarla düzeltilmesi ya da silinmesi önem arz etmektedir. UYAP Vatandaş Portalı vasıtasıyla bu önemli olduğunu düşündüğümüz eksikliğin giderilebileceği değerlendirilmektedir. Listemizin en çok işlem yapılan ikinci hizmeti olan
This video, let's continue the same. Thank you for
Merhaba.
listening and watching.
Good morning, teacher. Have a nice day. My name is Jamile Ebu Cemil, and I will give you two examples about the e-justice. I will talk about the e-justice in European Union and America. First of all, we will start with the e-justice in European Union. I will talk about the courts, the e-courts in the European Union. In most member states, there are different branches of courts. Generally, there are three main types of courts can be identified: the ordinary courts, specialized courts, and the courts dealing with the constitutional matters. The ordinary courts usually deal with the disputes in civil matters or criminal matters. In addition, many member states have established courts for specific matters, such as disputes between public authorities and citizen or business. Moreover, various member states have an institution of or court to ensure that their constitution is respected. Many of these courts or institutions can be asked to verify whether a certain law of legislation is in the line with the constitutional requirements. Some of them can hear individual cases, but usually only as a last resort. And in the second slide, we will continue with the e-courts in European Union. Beyond the information provided in the country-specific page, you can find valuable information on the following European websites. By the way, European Union, European Judicial Atlas. This website contains a search tool to identify the component code, and this website it's about the tour of Europe. And this website you can find the information on the member states Supreme Courts. Let's go to the fifth slide. We will talk now about how you can find the right court for you if you are living in Europe Union. If you are involved in a judicial proceeding, or if you accept to be involved in one, you will need to identify the court that is component to deal with your case, or in other words, which has a jurisdiction. If you address the wrong court, or if there is a dispute over the question of jurisdiction, you run the risk of considerable delay in the proceeding, or even of a dismissal of your case because of a lack of jurisdiction. And if a court case has a cross-border dimension and involves, for example, parties living in different member states, you will first have to identify in which member state the proceeding should take place. You have to say what in which place you are living in. And the portal section going to court can guide you through this process. This link can help you to go to the right portal. And now we will talk about the other judicial authorities in institution. Beyond the courts in Most member states, the judicial system compares other judicial authorities and institutions that exercise public authority, such as public prosecutors or, in certain cases, state attorneys. Public notaries or bills as for private lawyers, notaries and related professions with important functions is in the judicial system. The public prosecutor's office or prosecution service, which is regarded as a part of the judiciary in many member states, plays an essential role in criminal proceedings. The responsibilities and status of public prosecutors vary considerably among member states. Related information can be found selecting relevant member states flag in the section Ordinary Courts and also at the following website. This website offers country profiles reading the EU member states and other European countries. And now we will talk about the e-justice in America. Let's identify what is CM and ECF meaning. CM and ECF, the Case Management Electronic Case File Program, is a joint program of the Administrative Office of the U.S. Courts and Federal Courts to replace old case management system with a system based on sharing technology, new software, and increased functionality. This system gives federal courts the ability to maintain electronic case files and to offer electronic filing of court documents over the internet. It makes it easier to use and to find and to control the criminal courts and everything. What does CM provide for attorneys and the public? Here is some benefits about CM and ESF offers for attorneys and public. Let's talk about them. The first benefit is the case information, including the docket sheet and the file documents, is available for viewing and downloading to attorneys and the public at any time from locations other than the courthouse. The second benefit is parties and the judge, the court staff, and the public can review the cases file simultaneously in easy way. They can review the case in easy way. And the third benefit is at the court's option, registered attorneys can file case documents 24 hours a day, 7 days a week. Yeah, it's opening in every time. You can control or you can see your electronic file and in any time over the internet. And the third benefit is a notification of activity in a case in the form of a notice of electronic filing is sent by email. The file and all registered participants in the case immediately after each electronic filed. And the last benefit is since CMF and ECF can be accessed using standard office equipment, the cost already is very low for the typical attorney. And now, who may view documents on CM or ECF systems? Subject to court orders in individual cases, policy, or the individual court elimination, the public may view dockets and documents in CM ECF systems through the Public Access to Court Electronic Records program. And are there fees associated with CM and ECF? Yes, there are no added fees for filling documents over the internet using. Also, existing court document filling fees to apply electronic access to individual case docket sheets and filed documents is available through the Public Access to Court Electronic Records program. And who will users learn how to file documents in CM and ECF systems? Actually, training is available from each court. If an attorney is trained in registered in one court, that attorney may be authorized to register and file in another court without further training, and at that court's discretion. Filling documents in CM and ECF easy. A minimal amount of training generally is needed. Many courts also have developed user manual for attorneys and other users, which are available on their websites. Attorneys should contact each court in which they wish to register and file for information about training requirements. And at the end, are documents filed in CM and ECF secure? Yes, there are two utility programs that verify documents. One program is used to verify the integrity of a PDF document as a file in CM and ECF, and the second one is a separate program runs automatically at preset times to verify that the documents have not changed since they were filed. Thanks for watching me, and that's all.